Turn around, put your hands right there real quick. You got anything on you? You shouldn't keep your hands out of your pocket.
I wasn't. I don't have anything on me, officer.
Put your hand behind your back.
Officer, I don't have anything
Put your
on
hands
me.
behind your back.
Officer, why are you? What? Can you just tell me, officer? Please, can you tell me what I'm under arrest for? Please, please. Officer, please.
Get out.
What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Our video today comes to us from Rusk County, Texas, and it depicts a traffic stop performed by Sergeant Shane Iverson of the Rusk County Sheriff's Office back in September of 2022. Iverson stopped a 29-year-old motorist named Timothy Michael Randall for a stop sign violation. He ended up ordering Randall out of the vehicle and shortly thereafter attempted to arrest him. Now, I obtained the footage from KLTV 7, which is an East Texas ABC affiliate. I've edited the video to exclude the actual shooting and some of the aftermath, but you should head over to their channel, watch the video in its entirety, and give them credit for covering this story. Let's watch the video and then we'll come back and talk about the law.
Five 17 County. 517 County traffic. Good evening.
How you doing, sir?
Good. I'm Sergeant Iverson of the Rusk County Sheriff's Office.
Yes, sir.
The reason I pulled you over is you blew that stop sign back there.
No, I didn't. I came to a complete stop with that stop sign.
All right.
I mean, I did. I came to a stop.
No, you didn't. So,
What do you mean? I mean, what do you mean?
step out of the vehicle for me.
Okay. I mean, can you show me that I blew?
Step out of this.
Okay. I'm just wondering.
Turn around, put your hands right there real quick. You got anything on you? You shouldn't keep your hands out of your pocket.
I wasn't. I don't have anything on me, officer.
Put your hand behind your back.
Officer, I don't have anything
Put your
on
hands
me.
behind your back.
Officer, why are you? What? Can you just tell me, officer? Please, can you tell me what I'm under arrest for? Please, please. Officer, please.
Get 517 County. .517. Dude, you okay? .517 County. Hey, I need an ambulance. Call everybody. I've got a shooting. Hurry up, I need an ambulance. I can't get out of my radio.
Okay, I'll get him out there. Okay, we got it today.
Okay, so as you might have guessed, the governing case law on the issues in this video are Pennsylvania versus Mims and Garner versus Tennessee. We'll touch on both of them, but the primary focus will be on Pennsylvania versus Mims because it's the ultimate reason that we get to a deadly force encounter here. So as most of you know, there was a case decided by the United States Supreme Court in 1977 called Pennsylvania versus Mims. It was about 9 years after Terry versus Ohio. The case really wasn't complicated at all, but for whatever reason, the Supreme Court decided to take it up. And there was actually a bit of controversy surrounding that. Mims had already served his sentence and had his conviction vacated by the Pennsylvania Supreme Court. But for whatever reason, the Supreme Court decided to get involved here and grant cert to basically decide after the fact on a nearly moot case to reinstate Mims' conviction. But the basic facts are that Harry Mims was a motorist. He was driving in Philadelphia. He was stopped for an expired registration by 2 Philadelphia police officers. The officer dealing with Mims, that was on the driver's side of the vehicle, had a routine of asking every driver he dealt with out of the vehicle, and his justification was that he felt safer in doing so. Now, in the opinion, the court basically says that the state freely concedes the officer had no reason to suspect foul play from the particular driver at the time of the stop, there having been nothing unusual or suspicious about his behavior. And they indicate that it was apparently the practice of this particular police officers to order all drivers out of their vehicle as a matter of course whenever they had been stopped for a traffic violation. So the state would argue in this case that the practice was adopted as a precautionary measure to afford a degree of protection to the officer, and that it may be justified on that ground. Establishing a face-to-face confrontation diminishes the possibility, said the court, otherwise substantial, that the driver can make unobserved movements. This in turn reduces the likelihood that the officer will be a victim of an assault. I actually have some arguments I'll make to the contrary, especially in cases where you have officers who can't physically handle themselves like what we have here, but we'll get to that in the closing. The court went further and said that the hazard of accidental injury from passing traffic to an officer standing on the driver's side of the vehicle may also be appreciable in some situations, and rather than conversing while standing exposed to moving traffic, the officer prudently may prefer to ask the driver out of the vehicle to step out of the car and off onto the shoulder of the road, where the inquiry can be pursued with greater safety to both. Now, if you pay attention to the language that the court's using in this opinion, it's opening up a bunch of different scenarios where it is sort of the subjective preference of the police officer, as long as it's related in some way in the way that it's articulated to officer safety. They're sort of given a blank canvas to police officers. Well, maybe you want to talk to somebody on the sidewalk instead of in the middle of the road. Or maybe you feel better because you can handle yourself and you want a face-to-face conversation. But they're basically saying, look, if the officer feels more comfortable and more safe asking the driver out of the car, we think that's okay under the Fourth Amendment. Because the case was overturned by the Pennsylvania Supreme Court, basically saying that the traffic stop was fine, but asking Mims to get out of the car was an additional Fourth Amendment violation. And so what the heart of the holding, there are 2 holdings in Mims, but the heart of the first holding is about the actual exit order, getting the person out of the car. And so what the court said was that, assuming the stop was lawful and the person is lawfully seized pursuant to Terry versus Ohio, the court reasoned that asking the person who's already lawfully seized to step out of the vehicle as a precaution for the sake of officer safety is not an additional seizure, and it rises to no more than a mere inconvenience when a person is already lawfully seized. Therefore, it's permissible under the Fourth Amendment. Essentially, that's what it said. Now, where a lot of people get confused, including lawyers, and misinterpret Mims is that they focus too much on the second holding in the case, and they sort of entangle the first and the second holding, and they're separate. The second holding was essentially about the pat down and frisk of Mims when he got out of the car. But when Mims got out of the car, the officer noticed in plain view that there was a bulge in Mims's jacket, and he feared that that was a weapon. And so, as a result, conducted a pat down and found a revolver. Now, again, a lot of people construe that in a myriad of strange ways. Some people say that in order to be lawful under Mims, the officer has to have reason to believe the person is armed and dangerous to order them out. That's not true. That's clearly not what was said. What was said was that the officer can order the person out in due course and it not be an additional violation. And then, if you look at the actual language of the second part of the holding, the court anchored the language to Terry. The court actually said in its holding, under the standard announced in Terry versus Ohio, whether the facts available to the officer at the moment of the seizure or the search warrant a man of reasonable caution in the belief that the action taken was appropriate. The officer was justified in making the search he did once the bulge in the respondent's jacket was observed. So again, once he observed the bulge and pursuant to the standard in Terry, this is for the pat down. not the exit order. Remember, the exit order has already been dealt with in the first holding. It's completely separate. It's basically officers giving an exit order in due course as a precaution for officer safety is not an additional Fourth Amendment intrusion where the vehicle is already lawfully stopped. So that doesn't get mixed in with the pat down. That's completely different. They were justifying the pat down based on Terry in the second holding. The first holding was what MIMS truly stood for, and that's about the exit orders. Another way that people commonly misconstrue MIMS is that they'll say that the officer has to have a subjective fear for his safety in order to get somebody out. That's not true either. If you go back and read the way that the opinion is discussed, it's obvious that everything about this is officer safety. And some people, even lawyers, go so far as to say that there's no officer safety component to MIMS whatsoever, and then an officer can order a person out for any reason or no reason at all. Again, I would respectfully disagree with all of those positions on MIMS based on my own reading. Honestly, as it relates to both a particularized fear theory and related to not even needing a reason at all, both are sort of ignoring the holding of MIMS. All of the discussion in the official opinion, as well as the dissents and the footnotes, are surrounding officer safety. So if you take a holistic view of MIMS and read the entire opinion and read the footnotes and read the dissents, it's all about law enforcement officers being assaulted, the studies that support certain positions and the disagreement about that. There's no discussion related to just getting people out of the car simply because you want to. So, at least in my opinion, officer safety has to be somewhat related to the reason that you're getting somebody out of the car if you're going to be compliant with MIMS. And the court later went on to tighten MIMS up a little bit in that regard when it decided the Rodriguez case in 2015, but we'll cover that in another video. Now, how does MIMS apply to this incident? So first, let's look at the first holding. You have to start with a lawful traffic stop for MIMS to kick in, right? Sergeant Iverson makes this stop based on a stop sign violation, or what he said was a stop sign violation. I want to draw your attention to something about that. So we'll pull up part of the video here, and we'll kind of walk through it as we go along. Now, you'll notice as we approach the intersection, we're ways away. And I've zoomed in the video here where Randall's car comes into frame. Around the same time, we see a speed limit sign on the right-hand side of the road that says 50 miles per hour. From the position the vehicle was in when Randall's vehicle comes into the frame, it takes Sergeant Iverson 12 seconds to get to that same intersection, that four-way intersection. So we'll give him the benefit of the doubt here and assume he was doing the flat speed limit of 50 miles per hour. 50 miles per hour is 73 feet per second. That means that Iverson's position when Randall's vehicle came into frame was at least 876 feet away from the intersection, at a minimum, at the time that he alleged that he saw Randall run the stop sign. Now, in most states, a person can stop at either the painted stop line, or if there is not a painted stop line, stop at a place in the intersection where they can see the traffic from all directions before they proceed. Now, just to put 876 feet in perspective, a football field is 120 yards, including the end zones. 3 feet in a yard, so that's 360 feet for a football field. So 876 feet is nearly 2.5 football fields away. So I think a very valid argument could be made here that no reasonable officer could see whether Randall did or did not come to a legal stop at the intersection in all of the places that he could have legally done so from 876 feet away as Iverson's vehicle was positioned. So I have some serious doubts that the stop was lawful to begin with. But second, what we see in the interaction and where this case relies on MIMS is that no one is safer in this encounter once the driver is out of the car. And that's always been my argument, and that was Justice Stevens' argument in the dissent, which we'll go over in the closing. Now, if I had to make an argument for the police, like gun to my head, I think the argument would become that when a person is given a police officer pushback, because we've all seen it, we know what happens here. The second that you start pushing back and you don't immediately bend the knee, it's step out of the car. It really is an intimidation tactic. But if I was being a empty vessel as an attorney and needing to argue whatever side hires me, right? If I was just being a soulless lawyer, as we all are at our core, I think the argument would have to be that when a person was given a police officer a hard time and the situation is escalating, the escalation of the encounter creates a higher risk that the officer is going to be assaulted or find himself in a physical encounter. And the courts, sadly, have allowed MIMS to give officers what I'd call pretty close to carte blanche authority in ordering people out of the car whenever they want to. And even though MIMS anchored the exit order to officer safety, and it gave such a broad range of officer safety topics that could be explored in the justification of asking somebody out of the car, almost anything can be argued as precautionary for officer safety. So if I was Iverson, I might say, well, I wanted to force a face-to-face encounter pursuant to the language of Mims because he was argumentative, and I thought I had a better chance of avoiding an assault if I could see his hands and get away from any weapons he might have in the car. Now, if I'm the lawyer arguing for the family here of Mr. Randall, what I say is that he didn't like being questioned, that this was an intimidation tactic designed to punish Randall for daring to question the police, and as the situation unfolded, it was Iverson who was ultimately the dangerous person here, not Randall. Upon the inspection of the video, you can see that when Randall complies with the exit order, he stuffs his wallet down in his back pocket. Well, that forces, the downward pressure there forces the front of his pants to come up. His response is to grab his belt and push the front of his pants back to their original position, and tragically, Sergeant Paranoia here saw that as a furtive movement towards his waistband and ultimately started a pat-down based on that. Now again, I believe he had no reason to think Randall was armed and dangerous, but I can tell you that a reasonable argument can be made that Randall's movement towards the front of his pants, which we, by the way, have the benefit of seeing from the side, was probably enough to alert Iverson to an idea that there might be something that he was trying to stuff. I disagree with it. I think it's chicken shit, but we do have to remember that our vantage point is, one, after the fact, and two, from an angle that Iverson couldn't see at the time. Now, Iverson feels something that leads him to attempt to place Randall under arrest. He thought it was a North American Arms 22, which is like a really small 22 Magnum that a lot of people will wear like on a chain necklace or something tucked under their vest or tucked under their shirt or whatever. He later reported that what he found on Randall after he was searched was a crack pipe. If the officer was being honest and he thought there was a gun in the guy's pants and the guy was giving him a little bit of a pushback and a little bit of a hard time, that he might be able to reasonably handcuff the guy, to pat down, to remove the gun, disarm him for officer safety. I know that you guys don't like that, and I don't like it either. I realize that being armed legally is something that shouldn't require us to be subject to patting down, but the courts have held time and time again that when an officer is dealing with you and he's got you lawfully seized, if you're armed, that's a danger for him, and so he can legally disarm a person in the process of dealing with that person, even if the person is not committing a crime by being armed. So that's what the courts have said. Now again, I don't necessarily agree with it, but we have what we have, and that's what we have. But what about the shooting itself? Well, Garner versus Tennessee controls that. At the time that the shot happens, Randall is not actually fleeing. He is just sort of resisting arrest and trying to figure out what in the hell is happening, would be my guess. He doesn't flee until after he's shot, which I think is pretty reasonable considering that it's very likely that in his mind, he was probably just shot by a completely incompetent cop who has slammed him on the ground and used unreasonable force to try and arrest him for some crime that he hasn't even committed, and he was scared and full of adrenaline, and so that's probably why he ran. But was the shooting itself justified? I would argue absolutely not. Although Iverson says he thought he felt a .22 revolver, it later turned out to be a crack pipe. He shot a guy he says he thought was armed, and the guy ran. Guys, I just realized as I was going through the editing process that I didn't actually mention the standard for Tennessee versus Garner. The standard for Tennessee versus Garner as it relates to using deadly force is that an officer can't use deadly force to prevent the escape of a fleeing suspect unless the officer has a good faith belief that the suspect poses a significant threat of death or serious bodily injury to the officer or others. And so I don't even know what this guy would be arrested for other than potentially resisting and obstructing, because again, even if he's armed, it's not a crime. So you won't have probable cause for an arrest there. He doesn't start fleeing until he's actually shot. And so I think it would be a stretch to make any sort of cogent argument that this would be a justifiable shooting under Tennessee versus Garner standard. Now again, I'll tell you that the case was submitted to the grand jury and it was not returned. It was a no true bill, which whenever you're indicted, it's true bill, and when it's no true bill, it means that there wasn't evidence sufficient for an indictment. The evidence sufficient for an indictment is so low that it's unbelievable to me that they couldn't get an indictment out of this case, but it is what it is. Usually they submit an indictment 3 times to the grand jury before they decide that the case is dead. So in theory, this case has been submitted to 3 different groups of citizens and asking for a minimum standard of probable cause for even manslaughter or some sort of unjustifiable use of force in this case in Texas, and they have declined to do that. We also have to keep in mind that in the grand jury process, process, it is the state and the local prosecutor presenting the case to the grand jury who decides exactly what gets put in front of the grand jury. And most of the time, grand jury proceedings are secret. So there's the potential that we'll never really know how much effort or how little effort was involved in trying to indict this case or what was actually presented to the grand jury. We don't know whether they saw the dash cam or any of that. We really just have no idea. There's a good chance that that has some bearing, at least, on whether or not the grand jury was able to see what we just saw when we watched this video in making its decision about an indictment. The only hope at this point would be that the Federal Department of Justice would have to come in and investigate this, prosecute Iverson for deprivation of rights under color of law, which I don't really see happening. I believe what we ultimately have here is a tactically incompetent, cowardly police officer who unnecessarily escalated a simple traffic violation that, by the way, he probably couldn't even prove into a deadly force situation. I hope his family wins a lot of money, but my prediction is that Sergeant Iverson will get away with this and probably won't even be fired. This is another case where the department fought for nearly 2 years to keep the public from seeing this dash cam, and it was just released a couple days ago after a federal judge ordered it. So for my closing, I'll leave you with Justice Stevens' dissent in Mims, which was almost divinely prophetic in its predictions that these things would come to pass. And what Justice Stevens said is, this case illustrates two ways in which haste can introduce a new element of confusion into an already complex set of rules. First, the court has based its legal ruling on a factual assumption about police safety that is dubious at best. Second, the court has created an entirely new legal standard of justification for intrusions on the liberty of a citizen, without any attempt to differentiate among the multitude of varying situations in which an officer may approach a person seated in an automobile. The court characterizes the officer's risk as inordinate on the basis of this statement. According to one study, approximately 30% of police shootings occurred when a police officer approached a suspect seated in an automobile. That statement does not fairly characterize the study to which it refers. Moreover, the study does not indicate that police officers can minimize the risk of being shot by ordering drivers stopped for routine traffic violations out of their cars. The study in question reviewed 110 selected police shootings that occurred in 1959, 1960, and 1961. In 35 of those cases, officers were attempting to investigate, control, or pursue suspects who were in automobiles. So you had 110 interactions, 35 of them were automobile related. Within the group of 35 cases, there were examples of officers who were shot through the windshield of the car body while their vehicle was moving, examples in which the officer was shot while dismounting from his vehicle or while approaching the suspect's vehicle, and apparently instances in which the officer was shot by a passenger in the vehicle. In only 28 of the 35 cases was the location of the suspect who shot the officer even verified. So there's 7 that we don't even know about. In 12 of the cases, the suspect was seated behind the wheel of a car. But that figure seems to include cases in which the shooting occurred before the officer had an opportunity to order the suspect to get out in the first place. And in 9 of the 35 cases, the suspect was outside the car talking to the officer when the shooting occurred. So there you have it, sort of distilled down to its minimal parts. You've got 12 where the person was in the car when they shot the officer. You got 9 where the person was outside the car when they shot the officer. So there's only a difference. One is 34% of 35, the other is 25% of 35, something like that. And you got 7 cases where you're not even sure where the suspect was. So if you took 7 cases and stacked it on the 9, well, then you'd have more people outside the car that shot the police than people inside the car. But again, you got 7 that you don't know about, 9 that were outside the car, and 12 that were inside the car. And the court really stretched and went out of their way to try to find this holding. That's what they wanted to do. This is the standard they wanted to set. Justice Stevens goes on to say these figures tell us very little about the risk associated with routine traffic stop, and they lend no support to the court's assumption that ordering the routine traffic offender out of his car significantly enhances the officer's safety. Arguably, such an order could actually aggravate the officer's danger because the fear of a search might cause a serious offender to take desperate action that would be unnecessary if he remained in the vehicle while being ticketed. Whatever the reason, it is significant that some experts in this area of human behavior strongly recommend that the police officer never allow the violator to get out of the vehicle. And this is the best part of the opinion. The court cannot seriously believe that the risk to the arresting officer is so universal that his safety is always a reasonable justification for ordering a driver out of the car. And then he gives examples that would come to fruition later. The commuter on his way home to dinner, the parent driving children to school, the tourist circling the Capitol, or the family on a Sunday afternoon outing hardly pose the same threat as a driver curbed after a high-speed chase through a high-crime area late at night. Nor is it universally true that the driver's interest in remaining in the car is negligible. A woman stopped at night may fear for her own safety. A person in poor health may object to standing in the cold or rain. Another who left home in haste to drive children or spouse to school or to the train may not be fully dressed. An elderly driver who presents no possible threat of violence may regard the police command as nothing more than an arrogant and unnecessary display of authority. Whether viewed from the standpoint of the officer's interest in his own safety or of the citizen's interest in not being required to obey an arbitrary command, it is perfectly obvious that the millions of traffic stops that occur every year are not fungible, or, in other words, are not interchangeable in the way that they happen. They're not the same. They're not conflatable. But to eliminate any requirement that an officer be able to explain the reasons for his actions signals an abandonment of effective judicial supervision of this kind of seizure and leaves police discretion utterly without limits. Some citizens will be subjected to this minor indignity, while others, perhaps those with more expensive cars or different bumper stickers or different colored skin, may escape it entirely. So he's signaling that this is going to be used against people of color, against minority communities, and against people who don't have enough money to strike fear in the hearts of the police officer. In a footnote to the case, the majority actually retorted that their holding is not meant to be construed to allow officers to ask anyone they deal with in any automobile to get out, which is why MIMS has generally not been seen as extending to encounters where the person is in a parked car and the encounter was not pursuant to a lawful traffic stop. And I can tell you that Justice Stevens' premonition has come true. MIMS has been so abused so much that every state I've researched has extended MIMS to include a bunch of stuff that has nothing to do with officer safety. And it has created a scenario where the narrow holding in MIMS has been broadened so much that it's basically become a justification for officers ordering anyone in or out of a car whenever they like. And even though it is all supposed to be about officer safety, everyone knows it's about control and intimidation. And the worst of it is found in cases like this, where the officer dances both of them through what I call the triangle of incompetence. It starts with an officer that has no de-escalation skills. That officer pushes an ordinary traffic stop into a physical situation that he doesn't have the ability to handle because he's tactically incompetent and clearly hasn't done anything related to fitness for a very long time. And so some innocent guy who, at worst, had an addiction problem that caused him to be no threat at all to Iverson has to die as a result of incompetence. And that's the problem with MIMS. It gives cops license to escalate situations they don't know how to deal with. People die and the taxpayers foot the bill. And what's really amazing is that the Terry case came out of Ohio, and it was about a concealed gun. And Ohio now has constitutional carry, so everybody can walk around with guns all over the place, concealed, whatever. It's amazing if you really kind of focus in on it, how our view of guns in this country has shaped our Fourth Amendment jurisprudence, because every single one of these cases were about concealed weapons, just about. And if this were to happen today, all of it would be legal and this would never be an issue. Anyway, that's all for this one, guys. Thanks for sticking it out. Please remember to like and subscribe and leave me a comment on the video. Watch some of the other videos on the channel. Leave me a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.